Welcome to Talk Trials.
Glad to be here.
You know, we often find ourselves digging through cases that are decades, sometimes centuries old.
Right, dusting off the history books.
But today, we're looking at something incredibly current. It's the Supreme Court's decision in Trump v. Illinois, decided just last month, December of 2025.
And this one is, it's really something else. It has all the drama of a political thriller, riots, federal agents under attack, but the whole thing pivots on, well, a dictionary definition.
It's such a strange contrast, isn't it? Real-world violence being decided by a fine point of statutory interpretation.
Exactly.
The core legal question sounds simple enough. Can the president federalize the National Guard to protect federal personnel and property when facing domestic violence?
You'd think the answer would be, well, yeah, of course. But the Supreme Court took a very different path. They looked at the specific law and essentially told the White House, nope, not like this.
Okay, so before we dive into the legal maze that is the court's reasoning, we have to set the scene. We have to talk about what was actually happening in Illinois, because this was not an abstract legal exercise.
Not at all. This was real. The situation on the ground, particularly around an ICE facility in Broadview near Chicago, was getting incredibly dangerous.
Let's paint that picture. We're talking about organized groups, described in the court record, showing up with tactical gear.
Right. This wasn't just a protest with signs. The record mentions shields, gas masks, even lasers.
The lasers were used to blind officers. They were also launching fireworks at them. And maybe the most disturbing tactic was doxing.
Posting the home addresses of federal agents online. It's a form of intimidation that follows them home. Just terrifying.
And it wasn't just intimidation. There was a specific incident on October 4th, 2025 that sounds like something out of a movie.
Oh, the vehicle ramming, yeah.
A Border Patrol vehicle was driving down the street and it gets ambushed, boxed in by 10 civilian cars.
10 of them. A planned attack.
And then 2 of the cars ram the federal vehicle. An agent gets out, probably disoriented, and another car drives right at him. He had to fire his weapon just to defend himself.
And this is the critical moment. You have federal officers under attack, calling for backup. And normally, you'd expect to hear sirens.
But you didn't. The record shows a Chicago police dispatch that explicitly said, and I'm quoting, "no units will respond."
Just let that sink in.
Right.
A call for help from fellow law enforcement, and the response is silence.
Broadview police, same thing. No response. So President Trump says, if Illinois won't protect federal officers, I will. And he federalizes about 300 members of the Illinois National Guard.
And Illinois immediately sues to block him. The case goes up, and the lower courts actually side with Illinois. They keep the Guard on the sidelines.
So the administration makes an emergency appeal to the Supreme Court for a stay, basically saying, please, let us use the Guard to protect our people while we sort this out.
And the Supreme Court said no.
The Guard stays grounded.
Right. And their reason had nothing to do with whether the violence was real. It all hinged on the definition of 2 words: regular forces.
Okay, let's unpack this, because this is the legal catch-22. The statute is 10 U.S.C. 124063. It says the president can call up the Guard when he is unable with the regular forces to execute the laws.
Seems straightforward.
Well, the government argued for years that regular forces just meant, their usual federal law enforcement, ICE, FBI, marshals. Their argument was simple. Our civilian forces are overwhelmed, so we're unable. Now we need the Guard.
That's the common sense reading. But the Supreme Court majority said, not so fast. They looked at the history of the term and concluded regular forces doesn't mean civilian police. It specifically means the U.S. military.
The actual Army, Navy, Air Force.
Exactly. So the statute now reads, you can use the Guard only if you are unable to use the U.S. Army.
But wait, why can't the president just use the Army then, or at least say he can't?
Because of another law, the Posse Comitatus Act.
I remember this one, post-Civil War, right? It's meant to keep the military out of domestic policing.
Precisely. It makes it illegal to use the Army to execute domestic laws, unless you're talking about a full-blown insurrection.
So if it's illegal for the Army to be there, doesn't that make the president unable to use them?
That was the government's entire argument. I'm legally forbidden by Posse Comitatus, therefore I am unable, therefore I can use the Guard. It seems completely logical.
But the court didn't buy it.
No, the majority opinion essentially said the government failed to prove they had exhausted every single potential authority to use the military. Because they couldn't first prove they could use the army, they couldn't then claim they were unable to.
That feels incredibly circular. It's like they're saying you can't unlock door B until you try to open door A, but door A is welded shut.
It's a very, very strict textual reading. And it's what absolutely infuriated Justice Alito in his dissent.
Alito really went for a common sense approach, right? He had that great analogy.
The suspended driver's license, it's perfect. He says, look, if your license is suspended, you are physically able to drive. The car works. But legally, you're unable to drive.
Because you'd be breaking the law.
Right. And for Alito, Posse Comitatus is the suspended license. The president is legally unable to use the army. End of story. The condition in the Guard statute is met.
He also seemed really angry about how the court even got to this regular forces equals military argument in the first place. He brought up something called the principle of party presentation.
He was. I mean, in simple terms, that principle says judges should be umpires calling balls and strikes based on what the lawyers present.
Okay.
But here in the lower courts, both Illinois and the federal government had basically agreed that regular forces meant civilian police. Illinois didn't even make the military argument.
So the Supreme Court just raised it on its own.
They did. Alito essentially accused the majority of grabbing an argument out of thin air that one side had already waived and then using it to rule against the government. He saw it as fundamentally unfair.
Wow. Now, speaking of the majority, we have to talk about Justice Kavanaugh's opinion. He sided with them to block the Guard, but he sounds really worried about it.
It's what we call a nervous concurrence. He agrees with the technical definition that regular forces means military, but he's clearly terrified by the real-world implications.
He gives this hypothetical that is just chilling, the Philadelphia courthouse scenario.
Yeah, let's walk through that. It's important.
He says, imagine a federal courthouse. A mob surrounds it with firebombs, threatening to burn it down with the judges inside. The local police are gone.
That's like Chicago.
Exactly. So the president needs help now. The regular army is hours away. And besides, he probably can't legally deploy them anyway. But the Pennsylvania National Guard is 10 minutes down the road.
The perfect tool for the job.
But under this new ruling from his own court, the president's hands are tied. He can't call the Guard because he hasn't technically proven he's unable to use the army that can't get there in time.
So the courthouse burns.
That's the implication. Kavanaugh seems to realize that by sticking to this rigid definition, they've created a dangerous gap in security.
And he points out the ultimate irony. If the president can't use the Guard, his only option left to save those judges might be to use his raw constitutional power and send in the actual military.
Which is the very thing everyone wants to avoid. The Guard is supposed to be the buffer, the de-escalation option.
A classic law of unintended consequences. Make the moderate option harder. And you might just force the extreme one.
There was also a dissent from Justice Gorsuch, and he was more focused on the process, right? The so-called shadow docket.
He was. The shadow docket is just the court's emergency docket. And Gorsuch's point was simple. This is way too complicated and important to decide in a few days on an emergency basis.
He felt they were rushing a decision on huge constitutional questions.
Exactly. The Insurrection Act, presidential power, federalism. He would have just granted the stay to calm things down and told everyone to come back for a full, proper argument later.
It's also fascinating, and it leads us to our next segment. It's time for us to step into the fray.
Let's do it.
Sitting as the 10th chair.
This is where we decide. If we were on the court, how would we vote on this emergency application from the government?
Thinking about those agents, the ramming incident, the no units will respond call, for me, it's clear. I would grant the stay.
I'm right there with you. Grant the stay, let the Guard deploy. My reasoning starts with just pragmatism. The term unable has to mean something in the real world. If a law like Posse Comitatus says you can't use the army, then you are unable. Any other reading just creates a dangerous legal fiction.
I agree completely. It creates a trap. You can't say you failed to use the army while also saying, but using the army would have been illegal. That's not how laws are supposed to function.
And my second point is Alito's procedural one, the principle of party presentation. It's not fair to change the core legal definition of the case at the final hour. The government argued based on one set of assumptions, and the court ruled based on another.
That feels right. And for me, I'd add a third reason, deference. I'd look back to that old case, Martin v. Mott from 1827. The core idea there is that in a true emergency, the president's on-the-ground assessment of a threat should be given weight.
A court is not in a position to second-guess the commander-in-chief about whether a mob with lasers is a serious enough threat.
So our ruling from the 10th chair is clear. Grant the stay, allow the Guard to serve its purpose as that critical bridge between civilian police and the regular military.
It seems like the only ruling that ensures the safety of federal officers and, frankly, the sovereignty of the federal government itself.
So let's do a quick recap. The Supreme Court blocked the National Guard from protecting federal facilities because of a strict interpretation of the term regular forces, which they said meant the U.S. military.
This created a catch-22, where the president couldn't use the Guard because he was legally barred from using the military first. The decision leaves a massive question mark over what happens when federal officers face violence without local support.
And of course, we have to give our disclaimer. Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Supreme Court.
We're just trying to make sense of it all.
But I do want to leave our listeners with one final provocative thought to chew on.
Okay.
Let's go back to that moment. The Chicago Police Dispatch saying, no units will respond.
The line going dead.
If a local police force can openly refuse to help federal agents under attack, and the Supreme Court then restricts the president's ability to send in the National Guard, does the federal government in that moment effectively lose its sovereignty over that piece of land?
That's a huge question.
Seriously, think about it. Was there a piece of Chicago that, for a few hours, was functionally no longer under the control of the United States government?
All hunting idea.
Thanks for joining us on Talk Trials.